2089. Please remember, he is present. Appearances, please.
Good morning, Your Honor. Alan Jackson, along with Jackie Speroni on behalf of Mr. Bohm, who is present in court out of custody.
David Marcos, along with Pauline Nazarian, for the people.
Thank you. There he is.
Hello, Your Honor.
Hello.
Mr. Calandra, he's here. We'd ask the court to recall the bench warrant that was, or the body attachment that was held till today's day.
So, thank you.
Thank you.
Okay. The matter's here for hearing on the 995 motion that Mr. Jackson's Speroni filed, which I have read and considered, as well as the people's opposition and the defense reply. I read all of those several times, as well as the preliminary hearing transcript, and I have reviewed the exhibits for the preliminary hearing that were admitted into evidence as well. Who's going to handle the, Mr. Jackson going to handle it? Okay.
The 995, yes.
Yes, sorry, obviously I've read your written submission, but if you would like to add to it, this is the opportunity.
Thank you. Your Honor, thank you, first of all, for allowing us to be heard on this. I will try not to repeat myself. Obviously, the court has read our submission, we've read all the exhibits, the preliminary hearing transcript, but I think that there are certain issues that do bear on the court's ultimate determination, and I'm going to highlight those issues as best I can and as succinctly as I can. And it starts with one truth, a legal truth here in California. Speed cannot be treated as malice. Speed cannot be treated as malice. That is the rule in the state of California. It's not made up by the defense, not made up by me. It's not a tagline. It's the rule of law in California recited in a statement handed down to the lower courts by the Supreme Court Justice Kelly Evans. Your Honor, this case has always required one thing and one thing only from the prosecution, and that is proof of implied malice. Not proof of negligence, not proof of recklessness, not proof that this was a tragedy, which it clearly was. They must prove implied malice, and the law is crystal clear that implied malice has two separate and independent requirements: an objective requirement and a subjective requirement. The prosecution has never satisfied either of those, certainly not at the preliminary hearing. And I want to be very clear, right now, at least for the first part of my comments, I want to separate those two into different legal pillars. The first thing I want to address is the objective requirement. What act did Fraser Bohm commit that objectively involved a high probability that it would result in death? That's the question before the court. That was the question before the magistrate. What happened on Pacific Coast Highway, I could not be clearer about this, was a tragic collision. But tragedy does not equal murder. And the law does not permit the district attorney to convert a fatal accident into second-degree murder simply by calling speed malice. Because we go back to that first postulate, speed cannot be malice in California. Your Honor, there was no alcohol, no drugs, no texting, no racing, no distraction, no prior DUI by my client, no advisements, no Watson warnings, no statement of indifference after the fact, no criminal history, no driving history, no bad driving history, no serious consequences imposed by the government in a judicial proceeding. Nothing that has ever been cited in the cases where implied malice has been upheld in California. So what are the people left with? What are they left with? All of those no's, one after another, after another, after another, Judge, all of those no's make them rely on one thing, and one thing only, and this is the basis of their entire theoretical postulate. Speed. That's it. Alleged speed at that. Disputed speed. Undefined speed. And now, after apparently abandoning that exact theory, which is what they argued at the preliminary hearing, they want this court to treat speed alone as implied malice. And that is not the law. That brings us to the fundamental problem in their briefing and in the magistrate's ruling. The prosecution has misstated or did misstate at the preliminary hearing the legal standard, and the magistrate clearly accepted that incorrect standard. They collapsed the two prongs of implied malice into one, the two prongs being the objective and the subjective into one prong, and they continue to do so even as recently as their reply. The reply brief that we received this morning states, quote, "The objective and subjective determination of the lethality of speed." That is a direct quote from the prosecution's reply brief from this morning. They still are conflating and combining the objective and the subjective factors, and the law says you cannot do that. And they're doing it on the back of, quote, "the lethality of speed." They go on to say in their reply brief, in a two-page reply, in addition to speed, he also lost control of the car. Well, Judge, by definition, every crash involving speed is also going to include the loss of control of the vehicle. Otherwise, no crash. And then they throw in as almost a Hail Mary, and by the way, the defendant, quote, "was aware that he did not have full control of his vehicle prior to doing so," end quote. No citation, no quotation to the record, no citation to the transcript, nothing. Just a blatant, bald-faced statement with no foundation in fact. Where is the evidence? What evidence did they produce and present to the magistrate that my client, quote, "was aware that he did not have full control of his vehicle prior to doing so, prior to speeding, prior to the collision"? There is none. They collapsed the two prongs of implied malice, as I just said, into one, and they applied pre-Reyes, and the court now is very familiar with Reyes, the 2023 version of CalCrim 520, both of which, pre-Reyes and the prior CalCrim, do not control. They are no longer the law. And the prosecution got the law wrong, and they argued the law wrong, and the magistrate, unfortunately, got that law wrong. The California Supreme Court's current rule on the objective prong of implied malice is set forth in the new 520 CalCrim, and the case is post-Reyes. Before we go any further into the facts, the record, the evidentiary defects that were at the preliminary hearing, we need to start with what the Supreme Court has already started for us, and that is the Reyes case. Because if this court applies the law as it exists today, which this court must do, not as it existed before 2023, then the murder counts cannot stand. They are legally infirm. Period. Full stop. The Supreme Court in Reyes made it unmistakably clear that to prove implied malice, the act itself must involve a high degree of probability, not possibility, probability, that it will result in death. That's not a risk, Your Honor. That's not a possibility. That's not dangerous in some generalized way. We can have possibilities and danger that still do not reach the level of implied malice. It must be a high probability of death, not just a probability. And that means significantly more likely than not. I tried, as I was preparing my arguments today, to put this in terms that ring true to we lawyers and the community members at large as well. A high probability of death means it is significantly more likely than not just 51%, not just more likely than not just the famous scales with a feather on, significantly more likely than not that you're going to kill someone when you commit that act. That you're going to kill someone when you commit the act. They rely on speeding. That's it. That's their entire theory. I've provided the court with 2 copies of the CalCrim. I just wanted to make sure that we're absolutely crystal clear about the language difference between those, the old and the new. They're marked. One copy is the calculator the people actually relied on. It was superseded and is no longer law. And one copy is the instruction post-Reyes, and that is the current law. In the old version, the objective standard, what I might have been arguing 10 years ago, before Reyes, highlights that, quote, the implied malice requires an intentional act. The natural and probable consequences of the act were dangerous to human life. So be it. That's what the law used to be. But the correct law regarding the objective standard now reads as follows. The defendant has implied malice if he intentionally committed an act. The natural and probable consequences of the act were dangerous to human life, in that the act involved a high degree of probability that it would, not may, it would result in death. The clearest language used by any court since Watson, defining a high degree of probability of death relating to traffic homicides, is the Moore case. The court explained in that case that Mr. Moore, the defendant in that case, drove 70 miles per hour on a neighborhood surface street, intentionally crossed into oncoming opposing traffic, causing other drivers to avoid him, intentionally ran through a red light at speed, struck a car in the intersection at speed without even attempting to apply his brakes, killed a passenger, and then evaded the police following that. And he did all of this, as he admitted, because of what he called, quote, wacky tobacco, end quote. That's a quote right out of the case, reasonably implying that he was high on marijuana at the time. The court in that case defined a high probability of death, and this is important, as a near certainty. A near certainty that the act would result in death. That's what a high probability of death means in California. Not that the act possibly could cause death, not that the act probably would cause death, not that the act was dangerous or even highly dangerous, but rather that it's a near certainty that the act alone would cause death. Did the people say or establish in any way at the preliminary hearing that the mere act of speeding on PCH, that's what their postulate is. The mere act of speeding on PCH is nearly certain to cause death. That is absurd. They did not, because they cannot. It is objectively not true that speeding on PCH nearly always causes death. In fact, it does not, and the people well know it. So that objective factor, and the act claimed by the people as a high probability of causing death, has simply not been met. It wasn't met at the preliminary hearing. Therefore, there is no implied malice to prove this case, or to prove those charges. That is the controlling law in California, and it's simply not the standard that the prosecution applied, and it's not the standard that the magistrate applied, respectively. The prosecution argued at the preliminary hearing what the magistrate ultimately accepted is the old formulation, that an act is sufficient to satisfy the objective requirement if it's dangerous to human life. And again, if we were standing here arguing this in 2015 or even 2022 before Reyes, I might not even be making this argument. But here we are in 2025, post-Reyes, and that's no longer the law. Danger is no longer enough. The Supreme Court expressly rejected that diluted standard and replaced it with a far, far more narrow standard. And that matters in this case. This is that type of case where the law actually makes a difference. The law actually defines what this court can and should do. Because failing the objective prong just ends the inquiry. We're just done. If the act does not objectively involve a high probability of death, there is no implied malice, even if the defendant was fully aware of the risk. And in this case, he wasn't, which I'll get to in just a second. The Supreme Court Justice that I referred to earlier, Justice Evans, has already anticipated and warned against the exact mistake that the people are making in this case. She literally saw it coming, the exact arguments that they're making, and warned the lower courts against that argument. In a published statement following Reyes, Supreme Court Justice Evans explained that lower courts in vehicular cases have been ignoring the objective standard applying an outdated CalCrim language and treating speed as if it were inherently sufficient to show implied malice. It doesn't get much clearer than that. She stated plainly, quote, and this is her quote, not mine, quote, speeding, even at a high rate, does not automatically equate to a high probability of death, end quote. That is not my characterization. That is a sitting California Supreme Court justice explaining that in vehicular cases, you must apply the Reyes standard, and failing to do so is reversible error. The fact is the people in their entire opposition relied on and stated the wrong law, and the magistrate got the law wrong as well. Justice Evans explained why that outdated law was changed. Why was it changed in the first place? Why even address it? She explained that thousands of Californians drive at excessive speeds every day without causing death. As the justice noted, just as drunk driving does not always or even usually result in death, either does speeding. That means speeding, even extreme speeding, cannot be treated as malice per se, which is what the people are asking this court to do, and what they asked the magistrate to do. There must be evidence that the act in the circumstances, the actual act in the circumstances presented, had a high probability of actually causing death. And here there is none. Not one witness, not one expert, not one data point, not a study, no, not one foundation of evidence that driving at X speed for X number of seconds has a high probability of killing someone. But people didn't even try to make that showing because they cannot. They relied instead on outdated pre-Reyes jury instruction, and the Supreme Court's already said that's manifest error. And as Justice Evans said, I just indicated, she warned courts, don't do this. Do not do this. The people are asking this court to do exactly that. If this court applies the law as it currently exists, as I've discussed it, post-Reyes, the murder counts have to be dismissed. Now we have the correct legal frame. I want to return back to the prosecution's theory, the one that they propounded at the preliminary hearing, and the one that they relied on in their opposition papers. At the preliminary hearing, the prosecution's argument was, there has to be a number where speed becomes murder. There has to be a number where speed becomes murder. It's undefined. There just has to be one, Your Honor, where speed becomes murder. That was their theory then. They told the magistrate that speed itself was both the objective and the subjective proof of implied malice, and even in their reply papers, they do the same thing today. Objective and subjective determination of the lethality of speed. They're still continuing to make the same legal error. That's not the law. There is no magic number at which speed automatically becomes murder. The law doesn't permit implied malice to be inferred from some undefined mileage per hour or even a defined mileage per hour. And the Supreme Court in Reyes and after Reyes has explicitly warned courts not to collapse those two objective and subjective standards or prongs into one single fact, like, for instance, speed. In the opposition, the people have abandoned their original argument. They've tried to replace it with something even more legally deficient. The idea that Fraser's general familiarity with the phrase, quote, speed kills, that slogan, proves both knowledge and conscious disregard. Because once he heard the slogan, or because one time he may have heard the slogan or saw it somewhere on the side of a bus or a bus bench. That is not proof of subjective malice. That is proof that the defendant is a human being who's seen the same public safety billboards that you and I have seen and the rest of us, everybody in the audience, have seen and are familiar with. Think about it. If this court, Your Honor, were to uphold the people's improper theory, every time there's a vehicular fatality, pretty much every time, all the officer would need to do is say, have you heard that speed kills? And if the unsuspecting driver says yes, now they're facing murder charges? Implied malice requires the defendant to have actually appreciated the specific danger of his or her act at that time. Not a general awareness that speeding somewhere, sometime, somehow may be dangerous. The requirement is this: I know the act is nearly certain to kill someone, and I'm going to do it anyway. That's the standard as set out by the Supreme Court. I know the act I'm about to engage in is nearly certain to kill someone. I'm going to do it anyway. That's implied malice. That's the subjective factor. Nothing in the record comes close to that standard, Your Honor, and the people know that, which is why they're trying to replace evidence with inference and slogans like speed kills. The people also want to rest on the fact that Fraser knew friends who died in an automobile accident at some point in his past. They want to suggest that that's enough for his subjective intent to consciously disregard the near certainty that speed can kill someone. Your Honor, we all likely know someone tragically who has passed in some sort of traffic accident. I'll bet if I asked for a showing of hands in this courtroom, very few wouldn't go up if I said, do you know someone or know someone who knew someone who tragically passed in a traffic accident? But under the law, that's not the same as being sensitized to the consequences of certain acts. That's what the law requires. We have yet to find any case in all our research in which that was the predicate for the subjective requirement. And yet every case that we have found, including Ortiz, which we cited, states the opposite. The subjective requirement can be established only from suffering serious consequences from the government because of your own conduct. That's Watson. This court knows that case inside and out. That's Watson. The defendant had suffered sanctions by the government, warnings by the government in judicial proceedings, in a judicial governmental environment, that warned him against the very act he then went out and did again. That is missing here. The people cannot replace Fraser's subjective knowledge with a traffic slogan and somebody else's traffic collision. That's not the law. The court has never done it, and I seriously doubt that this court wants to be the first. Thus, the prosecution cannot satisfy the subjective component either of murder or implied malice. There's no evidence, none, that Fraser Bohm believed he was actually traveling at 100 miles an hour, or 90 miles an hour, or 80 miles an hour. There's no evidence of that in the record whatsoever. The unrefuted evidence of what was subjectively in Fraser's mind is, and the court read the transcript, I don't know, I don't know, I don't know, when asked over and over and over, how fast were you going? He said, I don't know. If Fraser did not know his speed and clearly, he could not have consciously disregarded a danger he didn't perceive. The Supreme Court has repeatedly said, you can't disregard a fact you don't know. Further, unlike in the Moore case, which I cited to the court a little bit earlier, and Gonzalez, which is in our papers, where the defendants admitted that they knew that what they were doing had a high probability of death, and they didn't care. They knew exactly what they were doing in both of those cases. The defendants in both of those cases said, I don't care. There's no evidence that Fraser knew what he was doing was, quote, nearly certain, end quote, to kill anyone, a high probability of death.
Nobody wears a sign around their neck saying, my intent is to do this. My knowledge is so-and-so. It has to be judged by their actions and by the totality of the circumstances, doesn't it? Nobody comes out and says, my intention is to kill somebody when they point a gun at someone. My intention is to kill you. Nobody says that. You have to base your judgment as to what their intent was and their knowledge on their actions and on the circumstances surrounding it, don't you?
Circumstantial evidence has to be used to a certain degree. Absolutely, I agree with that. Nobody wears the sign around their neck saying, I intend to do this. But in every case in which that subjective knowledge has been imputed to a defendant, in every case, Ortiz, Gonzalez, Moore, all those cases have evidence in the record that the defendant knew what he was doing had a high probability of death and then ignored it, intentionally ignored it, through his statements, through his conduct after the fact, through fleeing after the fact, trying to avoid prosecution after the fact, saying, I knew I was going to go through the intersection. In Moore, for God's sake, The man drove through an intersection, killed a pedestrian, drove home, then said, when the officer said, well, you know what you did, didn't you? And he said, yeah, I think I cut the guy in half. It was disgusting. And there was subsequent post-conduct comments by all of those defendants to suggest they knew what they were doing and didn't care about it. That's the inferential evidence that was used in those cases, and that's what I'm highlighting to the court that we don't have with Fraser. He didn't know how fast he was going. He did not have that information.
That post-accident conduct, as disgusting as it was a factor, but it wasn't in and of itself determinative.
It was a factor that they used in addition to the other factors to indicate inferentially that they knew that their conduct, that speeding on surface streets, high rate of speed, going through an intersection, etc., was inherently dangerous to a point that it was in that, as the jury instruction says, in that there was a high probability of causing death. That's what's missing, Your Honor. The court is exactly right in highlighting this. Of course, nobody's going to wear a sign or send a voicemail saying, I know what I'm about to do is nearly certain to cause death. The problem with the prosecution's case and the magistrate's holding order is that there's no evidence. The record is completely deplete of evidence that Fraser knew how fast he was going. That's why I brought up his statement.
How would somebody driving 100 miles an hour, or 90, or whatever the speed actually was up in that range, not know that you're going super fast? How would you not know that? Realistically.
Super fast is not the standard.
No. But answer my question. If you're driving a car 95 miles an hour, you know you're not driving 40. Am I wrong about that?
You're not wrong about that. But speed alone is not.
I understand that.
Speed alone is not. It's enough.
But to gauge a person's knowledge of what it is that they're doing, the consciousness of it, you have to use common sense as well. And I'm sorry, when you're driving 95 miles an hour, 100 miles an hour, you know you're driving extremely fast. You know that.
If other cars are driving 70, 75, 80 on Pacific Coast Highway, which, Your Honor, they do all the time. I mean, now we're just talking about perception, right? Now we're talking about the court's perception. You must perceive that you're going fast. I was on that road 2 weeks ago. There were sports cars passing me. I was going 70. By the way, that was above the speed limit. Didn't realize it because every car next to me was either going the same speed or going faster than me. It's a perception issue. It's not like he was going 70 or 80 or 90 miles an hour, whatever the speed is, which the prosecution cannot define in a 25 mile an hour zone right next to a school. He's on PCH. And other cars are going similar speeds. Yes, he may have been going faster than the cars next to him,
Yes.
but not to a degree that it's a near certainty to cause death.
Well,
And that's the point at which it would have to be.
I'm going to discuss the testimony for Freeland and what the underlying facts of the case are, but just as a preview, all of the evidence from the civilian witnesses in the case is that the defendant zoomed away far faster. They couldn't even come close to saying with him he was driving so fast.
Sure.
He was hundreds of yards ahead at the time of the crash.
The witnesses, not a single witness at the preliminary hearing put him going 100 miles an hour. Not a single one. As a matter of fact, the witnesses that were asked how fast do you think he was going, they estimated him going around 70. That was in the preliminary hearing transcript. I wasn't there. That's what they said. That is not extraordinary, and certainly that's not enough to suggest a near certainty that someone is going to die. It's just not enough. I'm not saying, and I don't want to get spun into a discussion or even an argument certainly with the court about, was it dangerous? We can all agree. Speeding is dangerous. We can all agree that it has a possibility of causing death or great bodily injury. We can all agree with that. That's not the law.
Can we agree that the faster you're going, the more likely it is to cause death?
Depends on how fast you're going. Absolutely depends on how fast you're going. We can all agree on this. According to Justice Evans, that's not enough.
Right.
That is not enough by itself. And that's the only thing the prosecution has. Speeding. That's it. And that's notable. The people routinely charge vehicular manslaughter, not murder, just as the court is discussing. in fatal speeding cases unless there's clear evidence of the subjective knowledge. 2 weeks ago, to that point, to the court's point, 2 weeks ago, maybe not 2 weeks ago today, maybe it's 14 days, 15 days, 13 days ago. It was October 25th. This same office filed manslaughter charges in a case called People versus Kirksey. The driver was speeding on surface streets, drove onto the sidewalk, struck and killed 2 pedestrians, severely injured 2 others, then fled the scene, then fled the jurisdiction. He was finally caught in Chicago 2 weeks ago. Killed 2 pedestrians, injured 2 others, fled the jurisdiction, and fled for the specific purpose of avoiding prosecution. Manslaughter. They didn't even approach murder charges in that case. If the law is anything, it's got to be deliberate. Fraser, by contrast, as established in the facts of the preliminary hearing, stayed at the scene, cooperated with investigators, no drugs, no alcohol on board, no driving history, no fleeing, no secondary criminal act, all of which this other case had. Like I said, if the law is anything, it has to be deliberated, and it has to be consistent. And that means that similar facts should produce similar charges. And less aggravated facts should never be charged more severely. Selective charging is not just unfair, Judge, as this court knows, it's unconstitutional. Here, there's not even evidence that Fraser intended to drive fast for its own sake. Every available piece of evidence supports the opposite, that he was reacting to events unfolding in the moment, including being chased, being clipped by another vehicle seconds before impact. That is not malice. I'm not arguing that it wasn't dangerous. That's not the law. The law is for malice. It has to be a near certainty to cause death, and he has to subjectively say, I know it, and I don't care. That's their burden. What we have before us is instinct, not intent, not subjective intent. This was not malice. This was an accident. Perhaps negligence, not murder. The people now argue in their papers that the cause of the crash, astonishingly, is irrelevant. That doesn't change his culpability. Let me say that again. The cause of the crash is irrelevant. Your Honor, this is a murder case. Causation is everything. If Fraser was clipped or swerved or reacted to external events, then his act was not the probable cause of death. That alone defeats the murder charge, and the people's own exhibits show driver's side contact with his car, white paint transfer, matching the damage to Ms. Ortiz's vehicle. The very facts that the prosecution sort of wants to pretend doesn't exist. And you cannot argue implied malice when the defendant's conduct was reactive rather than intentional. Your Honor, Section 995 exists for exactly this reason, to purge charges that sound grave but rest on legally unsupported theories. The Supreme Court has repeatedly instructed that 995 motions must be granted when the magistrate applied the wrong legal standard, not just where the evidence is weak, but where the governing law and the governing elements were misapplied. And that's what happened in this case. It's precisely what happened here. Judge Edward did not get the law right. He accepted the people's there must be a number, there must be a speed theory, and that's legal error. The people continued to cite to the court outdated law, and that is legal error. The controlling standard for the objective requirement has never been met, and that's legal error. Once the right law is applied, the outcome is no longer discretionary for this court. It's not even close. It's not debatable. It's mandatory. If Reyes governs, and Reyes does, I think we're all in agreement, including Mr. Marcos, that Reyes now governs. If the current CalCrim 520, which I placed on the court's bench, governs, and I think, again, we're all in agreement that it does govern, then the murder counts must be dismissed. The case comes down to this, and I'll close my closing comments are these. There's one unavoidable question. Did the prosecution present evidence that Fraser Bohm committed an act involving a high probability of death at the time, that he knew it and that he intentionally disregarded it? The answer is no. Not a little bit, not barely, not depending on how you look at it. The answer is just no. No intoxication, no racing, no text, no statements of indifference, no prior warnings, no subjective awareness, no prior serious consequences by the government, no bad driving in his history, ever. And no objective showing of a high probability of death to a near certainty. Just speed. And speed is not malice. Section 995 is that safety valve, the safety valve that every member of the community relies on. It prevents exactly this kind of overreach. And the law demands that the murder counts be dismissed so that this case can proceed on the proper charges, the charges the evidence actually supports. Manslaughter, not murder. We ask the court to dismiss counts 1 through 4. Any reasons?
Jackson, thank you.
Thank you. The defense rightly points out the change in California 520, including the language of high probability that that was the result. But they just ask a question if the people presented that at preliminary hearing. Well, it appears that the judge who held the defendant to answer believed so, when in his holding he said, quote, implied malice requires that the defendant act with a wanton disregard of a high probability of death. That's from the preliminary hearing transcript, volume 3, page 47, lines 14 through 15. The committing magistrate clearly understood the law and applied the law to the facts that he heard. And we're here for a 995 motion. And the question then is, were there sufficient acts for him to draw that conclusion? Understanding he was applying the very law that counsel's been saying he did. I did want to note one thing in terms of the high probability. One of the cases cited by the defense was People v. Pierce at 114 Cal App 5th 508. And in Pierce, they confirm that there has not been a fundamental change to the law. They say, quote, finally, we note that the defense contends the High Court in Reyes, quote, changed its position on the objective component of implied malice and redefined dangerous to human life as requiring a high probability that the defendant's act would result in death. Contrary to the defendant's argument, the requirement that an act carry, quote, a high probability of death is not new. And Reyes itself noted the equivalence of the Thomas and Phillips formulations, those which came before, restating that the language that already existed stood for the same thing. This is a refinement of the language. And in fact, in the Pierce case...
Why did 520 have to be changed?
No, because it's stating that this already exists, that this is not new. This is the formulation. The change of 520 was a refinement in the language. The standard has always been that the failure to act, even from the previous language, the natural and probable consequences of the act were dangerous to human life.
That's not the same as, that's not as stringent as the requirement.
It is different language, but the point was that that was the language that was provided to, in this case, a jury. And the court upheld the conviction, stating that the language was sufficient based on what was provided to the jury at the time. So the question now that we're facing is whether there was sufficient evidence presented to the committing court in order for there to be the order holding to answer. And the defense has said time and time again that speed alone is not sufficient. And speed in isolation is not the determination. Watson and all of its progeny, again and again, they don't provide any definition of what implied malice is, they talk about the circumstances and how every case must be evaluated on its own circumstances. There is no number that's ever provided by the court. This isn't a case of speed in isolation where the defendant was driving down an open road with no other vehicles, with no other cars, pedestrians, just flying and reaching high speeds. This is a case where the crime took place on a stretch of road that has homes on both sides, with driveways and garages leading directly onto the street, with other vehicles that were going the speed limit at the time that he was driving, cars parallel parking on the side of the streets, and pedestrians walking on those sides, given that that stretch of PCH, which the defendant said that he was familiar with, doesn't have sidewalks. This was all information known to the defendant at the time that he decided to engage in the behavior that he did. The speed that we're talking about has to be looked at in terms of where he was and what he was doing. It isn't just that he reached the speeds that he did, he also had to navigate around other vehicles that were going slower. And that evidence was presented at the preliminary hearing. And that he went around because, even according to him, the vehicle in front of him was in his lane, so he drove around. And that's when he was reaching those high speeds. Now, he claimed that that vehicle then started to merge into his lane. So first, let me talk about that in terms of my moving paper saying that about the cause of the accident. The defendant's conduct was the proximate cause of the accident, or the collision, I should say. There is not evidence presented at preliminary hearing or anywhere else other than the defendant's statement that there was any contact between the defendant's vehicle and another. And the physical evidence shows that that did not occur. I don't understand where
The mirror was
the mirror was.
It was out of place.
It was out of place. The mirror was out of place in a position that one would not expect to have happened if it occurred while the defendant was passing another vehicle. One would anticipate the mirror would be knocked back as it struck, as it's moving forward, and it would be knocked backwards. The defendant's mirror was knocked forward, and that was after he had exited his vehicle. I could not say exactly how that occurred, but it does not appear that it would have come from striking that other vehicle. And certainly being the fact that the other vehicle suffered no damage on its mirror. The important point then is that this other vehicle is part of the issues that the defendant faces when he gets his vehicle up to the speeds that he did, because people change lanes. And if the defendant is attempting to pass on the right at speeds of 104 miles an hour, and the vehicle starts to turn, he does not have sufficient time in order to control his vehicle. And I did want to point out that the one thing that the defense didn't talk about was the fact that the defendant said when that vehicle came into his lane, he swerved to avoid it. We had the electronic data from the airbag system, and that was presented and put into evidence, and there was no swerving to what will be the light to the right. The only inputs were still left. The only steering inputs at all were to the left, contrary to what the defendant said. And as I noted in my moving papers, and I won't go into great detail, but it does show that the defendant understood that what he was doing was dangerous, and he is coming up with excuses as to why the collision occurred. The other important factor about the speed and the electronic data control is that at the outset of its recording, which occurred 5 seconds prior to the first deployment of an airbag and some 7 seconds before the final deployment, those inputs included an engagement of the stability control system, meaning the vehicle was not stable in its movement. In fact, we heard testimony at the preliminary hearing from Miguel Cucino that he observed the defendant's vehicle skid, lose traction with the road as he saw it then speed off. He said he could see the puff of smoke. According to the electronic data, that occurred when the defendant was doing 93 miles an hour and had his accelerator at 79%. He continued to accelerate for another 4 seconds after the vehicle lost traction with the road. As the court said, this isn't just he's going faster and doesn't notice, as Mr. Jackson said. He is being warned by his own vehicle that he does not have control, and yet he exceeds even that speed, which is already far above the limit, and continues on to what the data reported as 104 miles an hour. How could he not have known? In regards to the defense saying that we are relying simply on a slogan to prove that the defendant had subjective knowledge of the dangers of his speeding. It was the defendant himself in the statement who turned the slogan into something personal to him. That he had 2 of his best friends die as a result of speed. The defendant had the knowledge. He admitted that he had the knowledge. The issue is, as Mr. Jackson pointed out, does that mean that forever he could be charged with murder if he exceeds the speed limit by a single mile an hour? And the answer is no. Probably not even 5 miles an hour. Probably not 10. It has to be that he exceeds the speed and does acts that demonstrate implied malice. And here, that's exactly what we have. He knew that the speed, and he said that he believed it was 130 miles an hour, caused the death of his 2 best friends. Again, I'm not saying that the number is 130, but he clearly has an understanding that these excessive speeds can result in death. And it's not certainty, it is more than remote, and I want to get the language right. In one of the citations, and this is from Reyes, citing People v. Cravens, the quote from a concurrence of Justice Liu, although an act that will certainly lead to death is not required, the probability of death from the act must be more than remote or merely possible. And that is absolutely what we have here based on the totality of the circumstances and the totality of the acts that the defendant engaged in, understanding that he had been driving in a manner prior to the excessive speed that was described as going from all the way to the shoulder, all the way to the other side, that he was engaging in behaviors that already drew the other driver's attention to him. And then, at that point, he decided to speed at such excessive speeds. And when I say excessive, we're talking about the actual speed limit was 43% of the speed that he reached. He was exceeding the speed limit by 231%. And as the court noted, this isn't just about the speed. It's about his knowledge and about where he is engaging in this excessive speed. And he said he knows PCH like the back of his hand. If he knows it like the back of his hand, he knows that people are putting out their trash cans. He knows that people are parallel parking. He knows that people cross on the crosswalk that is demonstrated in the exhibits that the defendant passed as part of his path towards where the collision took place. He knows this, and yet, with that knowledge, with the knowledge that he is already losing control of his vehicle due to the speed, he continues to press down that accelerator for another 4 seconds. And that totality is the basis that the magistrate used to hold the defendant to answer. It is not that there has been no evidence, but there has been an abundance of evidence, more so than is needed. But the point is, at this hearing, it's whether that evidence was presented sufficient for the magistrate to hold the defendant to answer, and it was.
Thank you. Any response, Mr. Jackson?
Very briefly, first of all, first thing I want to mention is that the math is wrong. Didn't exceed the speed limit by 230%. The math is wrong. The speed limit was 45 or 50. 230% would be 145 miles an hour. That's absurd. 100% is double. 100% on top of that is the 45 again. So let's get the math right. It wasn't, was he speeding? Sure. But I don't want to get ridiculous about this. 230 times? I want to know, what the hell was he in a jet? You got the math wrong. Let's talk about the facts. Provable facts. Mr. Bartos says he was speeding. Okay, that's in a bucket. He's been saying that from day one. He's searching, and the prosecution has been searching and grasping at straws for anything other than that. There are homes at the side of PCH. That's dangerous. There are driveways leading out to PCH. That's also dangerous. There's cars parked along PCH. Boy, that's dangerous. There are trash cans. People have to put their trash cans out. That's dangerous. There's no sidewalks, and yet there's still pedestrians crossing the street. It's also dangerous. He went around some slower traffic, so says Mr. Bartos. Is that dangerous? Maybe, maybe not. And going at a higher rate of speed gives you less time to react. It's also dangerous. Where in that list did Mr. Bartos establish a high probability of death? That's the standard. The prosecution has gotten into this spin cycle non-stop since the preliminary hearing. Boy, this was dangerous, this seemed dangerous, this is dangerous, this is dangerous. That's not the law. As the court rightly termed, the jury instruction, it was changed for a reason. The Pierce case didn't stand for the proposition that it's all the same. It's always been a high probability of death. That's not true. The Reyes case changed the law. And the jury instruction was changed because of that, as the court noted. We are not talking about something that's dangerous. Is excessive speed dangerous? If we go out on Van Nuys Boulevard, whatever the big boulevard is, I think Van Nuys Boulevard, outside the courthouse, how many folks are going to be speeding on that road? We can look for 10 minutes. How many folks are going to be speeding on that road? Nearly all of them. Nearly all of them. It's California, for God's sake.
I don't like the way you're talking about Van Nuys.
Fair enough. Fair enough. I'm making the point, but I don't mean to upset a community, but I'm making the point that speeding can be dangerous, probably is dangerous, but it doesn't in and of itself reflect a high probability of death.
What circumstances would, in your mind, represent a driving that evinces a high probability of death?
If he was high, but he was speeding.
Whether you're high, you're drunk, or whatever it might be, equally, and you're therefore likely to cause some kind of accident. Who's to say whether this accident with drugs or that accident without drugs is more likely to happen to hit a vehicle or a pedestrian and kill them?
Let's say that there's a circumstance in which
Isn't there a large degree of bad luck?
luck is not enough. It has to be, yes. Sometimes accidents always happen to a certain degree because of bad luck. But the question becomes, when is it elevated to murder? That's why manslaughter exists. Judge, that's exactly what you're explaining is why manslaughter exists. Because sometimes people are doing things that are inherently dangerous, they shouldn't be doing it, it costs somebody their life. In every manslaughter case, it's important to reflect. I'm not standing up here asking that the entire case be dismissed. I'm saying let's call it what it is. In every single manslaughter case, every one, someone died. by definition, someone lost their life. If what Mr. Bartos is saying is right, basically, well, the car has a system on it that engaged. It was a traction control system. The car's telling him what he's doing is just about to lose control of the car. Well, first of all, that's not how traction control systems work. There's a beep that goes off or a light that goes off on the dashboard. You never hear it. I've got traction control in one of my cars, and you never know that it's going off or isn't. It's embedded in the EDR system, but it's not tapping the driver on the shoulder and saying, hey, slow down. That's not how it works. The question to answer the court's, the answer to the court's question is, what would show a high probability of death? Street racing at 100 miles an hour on surface streets. High probability of death.
Why is that anymore?
Because
more
street
likely to
racing,
cause death than just driving 100 on your own?
because street racing by definition is competitive, and you're constantly trying to outperform the other car. It's coordinated, and you're intending to go as fast as your car will possibly take you. That's the point of street racing. Street takeovers, where you're doing donuts surrounding pedestrians. Nearly every one of those cases that's prosecuted, if a pedestrian gets clipped by a car drifting in circles, gets clipped and gets killed, nearly every one of those cases is prosecuted as a murder. Why? Because it's not just excessive speed, it's losing control of the car on purpose with a pedestrian standing five.
It's not on purpose.
Drifting is losing control of the car going out of sorts. In other words, driving it in a manner in which it was not designed to be driven. It's drifting, by definition. So you have far less control. No car is designed specifically for that. It has to be in the hands of a professional. So these street takeovers, they kill people all the time. And normally those are prosecuted as murder cases. Why? Because it has the added effect. You're not just speeding like on the 405 to get around slower traffic. Driving on a sidewalk. Driving when you're evading police. There's always an additive to just speed. That's what Justice Evans was saying.
What about the environment? Mr. Bartlett sort of touched on an example that I was going to raise as well, which is, don't you have to consider the environment and the circumstances? There's a difference in the risk of death in driving 100 on PCH versus, some, far out, desert road where you're on a straightaway, there's no other cars, and nobody's around, and you can just gun at 100 and not have to turn the wheel. There's a difference between that and driving on a dangerous crowded road like PCH, isn't there?
They're both dangerous, but neither one of those, by just driving fast alone, neither one of those include a high probability of death. People do it every day, Judge. On PCH, they do it every day, and no one dies. It doesn't include a high probability of death. This is an incredibly high burden. We're not saying that it wasn't dangerous. I'm not suggesting that there wasn't a possibility that someone could get hurt. I'm saying that there was not a high probability of death such that Fraser Bohm should be saddled with murder charges. These are the same charges that Brian Koberger is facing. That's the point. Brian Koberger broke into a dorm and slaughtered 4 people. He's facing 4 counts of murder, a plea deal. 4 counts of murder. It's murder, Judge. That's the point. That's what the magistrate misunderstood. Is it dangerous? Sure. Is there a possibility that someone could have gotten hurt? They did get hurt, so clearly there's a possibility. Was there a high degree, a near certainty, as the Moore case put it? Was there a near certainty, a high probability that someone would die that night at that time, and that he knew it and disregarded it? The answer is no. It's resoundingly no. We don't have to like it. I'm not asking anybody to like what happened or to justify what happened. I'm asking the court, call it what it is. We are objective purveyors of the law. That's what we do for a living. We don't use emotion. We don't supplant tragedy for the law. We don't supplant emotion for the law. It was tragic. It was emotional. It's devastating. That wasn't.
None.
Thank you.
Thank you. Anything in response to that, Mr. Rogers?
The only thing is the evidence was sufficient for the magistrate, and he was correctly applying the facts to the correct law. Anything beyond that would be this court using its own decision-making, which is not the purpose of 1995. It's simply the determination whether there was evidence presented on which the magistrate could rely, and there was.
Submitted by both
I
sides.
submitted, Your Honor. Thank you.
All right, thank you. So first of all, well, I'm sure counsel is aware, I'm going to just put it on the record in any event, standard for a 995 motion. According to the ride-out of the Superior Court case, 67 Cal 2nd 471, reasonable and probable cause is shown if a man of ordinary caution or prudence would be led to believe and conscientiously entertain a strong suspicion of the guilt of the accused. That's the magistrate's job. The Mandela case, 1983, 33 Cal 3rd 754, reaffirms that the magistrate's finding of probable cause should stand if supported by any rational interpretation of the evidence. If there is some evidence supporting the magistrate's conclusion, the information will not be set aside. Some evidence. People versus Superior Court, Decker, 2007 case, California Supreme Court case. The reviewing court asked whether the evidence provides a rational basis for believing the defendant could be guilty of the charged crime. Every legitimate inference that may be drawn from the evidence must be drawn in favor of the information. The judge, in my position, is not to reweigh the evidence or judge the credibility of witnesses. At the 995, the question is whether there was simply probable cause to hold the defendant to answer, and that's all. So I'm going to discuss the facts here, and then I will discuss the law that applies to counts 1 through 4. There's no doubt the defendant was driving extremely fast on the PCH. All of the witnesses described it. They put different numbers on it, but they all said things like he was going, quote, extremely fast, or he, quote, flew past me, or he was going, quote, super fast, or that he, quote, accelerated extensively. The data recorder in Mr. Bohm's car said he was doing close to or even above 100 miles per hour in the instance before the crash in a 45 zone. The magistrate noted the data recorder evidence carried weight in his decision-making, acknowledging that while there are warnings that come with it that say it can make mistakes, there was no evidence presented at the preliminary hearing in this case that it made errors here. The defense said that Mr. Bohm was fleeing a road rage incident with Mr. Victor Calandra, but there's no evidence of that in the record. The evidence in the record was that Mr. Calandra, when stopped next to the defendant at a light a few moments before the crash, rolled down his window and warned the defendant he needed to be careful, yelling at him, "You need to be more careful, you're going to hurt yourself." Mr. Bohm did not respond. On cross-examination at the prelim, Mr. Calandra said he also included, "Slow down." And he also said he might have said, "You're going to hurt yourself or someone." He said those things because he had seen the way the defendant was driving prior to stopping at that light. He testified the defendant was driving erratically and drifting extensively and speeding. Why else would he say those things to Mr. Bohm if he hadn't seen him driving in such a dangerous manner? That does not sound like road rage to me. The defendant did not even react to Mr. Calandra. When the defendant took off from the light, he zoomed away from Mr. Calandra, and there's no evidence that Mr. Calandra accelerated in any attempt to keep up with him and chase him. The attempt to back this defense theory of the case with evidence of a prior incident that Mr. Calandra was involved in did not succeed at the prelim, as Mr. Calandra's testimony was that in that prior incident, the other driver pulled him out of the vehicle and attacked him. Maybe other evidence will be discovered or developed as to that incident as this case goes forward, or maybe not. But the testimony at the preliminary hearing in this case was Mr. Calandra's recounting of it, and that was all. Defense also argues there's evidence that his driver's side mirror was hit somehow during this incident by a white car. Mr. Calandra's truck was bright blue. And that I think the argument is intended to be the contact with a white car was somehow causal of this crash. There is evidence that the mirror was damaged. The Ortiz sisters were both driving white vehicles, but neither said they had any contact with the defendant's vehicle, and both said the defendant zoomed off from the light and was way, way, way ahead of them at the time of the crash. It would undermine any causality if there was contact between one of those white vehicles and Mr. Bohm's vehicle. Mr. Calander also said the defendant was several hundred yards ahead of him at the time of the crash, and his speed was excessive, at one point saying 80 to 85 miles an hour. We did tell the detective it was maybe 70. Mr. I hope I'm not mispronouncing it, Strucchino said the defendant passed the white cars, was going very fast, and was perhaps as much as 600 meters ahead at the time he swerved and then the crash happened. No matter who is more accurate, it's clear the defendant was far, far ahead of all these other cars at the time he lost control of his vehicle, even if he had previously bumped into one of those cars and damaged his mirror, although there's really no evidence or no testimony that that happened, other than the defendant's statement to deputies later. As far as the evidence of the defendant's statements go, the most salient ones for purposes of this motion are that he understands the meaning of the aphorism, speed kills, which he affirmed to deputies. But it wasn't just, yes, I know what that means, I saw it on a bus bench or the side of a bus, as you termed it, Mr. Jackson. He in particular knew what it meant because he said that his two best friends, as he described them, had been killed in a high-speed accident. And then he also said that he knows PCH, I'm quoting here, like the back of his hand, because he lives nearby and drives the PCH all the time. Well, if he knows the PCH that well, then he in particular would know how dangerous a road it is, how frequently accidents happen on it, and he would presumably know where a dead man's curve, where this accident happened, is. Those are the basic facts of the case as I gleaned them from the preliminary hearing transcript. Turning to the law, I'll just state it. Murder is the unlawful killing of a human being with malice aforethought. Malice may be either expressed or implied. It is expressed malice when the defendant manifests a deliberate intention to kill, which of course we do not have here. Malice is implied when the circumstances attending the killing show an abandoned and malignant heart. Malice should be implied when the killing proximately resulted from an act. The natural and probable consequences of the act were dangerous to human life in that the act involved a high degree of probability that would result in death. That is the new formulation. At the time he acted, this is continuing with the definition of implied malice, the defendant knew his act was dangerous to human life and he deliberately acted with conscious disregard for human life. Implied malice requires the defendant act with a wanton disregard for the high probability of death, thereby requiring a subjective awareness of a high degree of risk of death. It is not enough that a reasonable person would have been aware of the risk. Malice, importantly here, may be inferred from the circumstances, all of the circumstances of the incident. Calcrim 520 defines implied malice as to be such that the natural and probable consequences of the act involve a high degree of probability that it would result in death, not merely a threat to or a conscious disregard for the safety of others, but that it would result in death. More than a possibility or a likelihood of death is required, the act itself must give rise to a high degree of probability that death would result. The defendant must personally harbor implied malice. I'm aware of the CARR case, which stated that a simple act of DUI is not enough for implied malice, that the defendant's actions before, during, and after the DUI were also relevant to the determination of whether malice existed. While a dangerous act may be insufficient by itself to establish that the actor had subjective knowledge of the risk, it may be a relevant consideration in finding malice. Importantly, implied malice is to be based on the totality of the circumstances before, during, and after the act. The prosecution must have proof specific to this defendant that shows his subjective mental state at the time of the act, that he knew and appreciated that his actions were dangerous to human life, and he deliberately acted with conscious disregard for human life. The prosecution quite right, Mr. Jackson must prove both the objective danger that the conduct presents to life, as well as the defendant's particularized subjective awareness of the risk of death emanating from his conduct and his disregarding of it. I don't think anyone could seriously contend that, objectively speaking, driving 100 miles an hour on PCH, other cars on the road, there are pedestrians, homes, restaurants, parked cars, people walking their dogs, and the like. I don't think anyone could seriously contend that the natural and probable consequences of that conduct in that environment, in that place, at that time, do not involve a high probability of death. Of course they do. What's difficult about this, and you sort of touched on this, Mr. Jackson, is it's very difficult to quantify the likelihood of death, because you're quite right. Sometimes people drive 100 and they don't have any accident at all. There's no way to know that because there's no accident, there's no reporting of it, and there's no statistics for it. So we're left to what we do have. The defense argument is that Mr. Bohm, knowing PCH like the back of his hand, as he said, cannot be said to have the subjective awareness that his speed would cause death, or be highly probable to cause death. But if he knows the highway so well, it's reasonable to assume that he knows what a dangerous road it is, how many accidents, including fatal ones, occur on it. He knows what and where the advanced curve is. This familiarity with the PCH does supply him with the subjective knowledge that his actions on it are dangerous to human life, and the subjective appreciation of the substantial risk of his actions on that road in that moment. The substantial risk of death occurring. That personal subjective awareness would have only been enhanced by Mr. Calandro's warning to him at the stoplight that he needed to slow down or he was going to hurt himself or hurt someone if he heard Mr. Calandro, which is not clear. I have reviewed the cases cited by both counsel in their motions. None of them are exactly like the facts of the Bohm case, but they do nevertheless provide guidance. I know counsel discussed these a little bit, but I will as well. In People versus Gonzalez at 197, Cal at 4832. The court held that the evidence was sufficient to find that and I know this was a pre-Reyes case, the court held that the evidence was sufficient to find that the defendants acted with conscious disregard for life and therefore to convict them for second-degree murder. Rejecting the argument, there was no evidence that they were aware of the risk involved in their conduct. This is the case in which the defendants had modified their cars to engage in street races. They consumed an unknown quantity of beer, raced side by side on a residential street, reaching speeds of up to 87 miles per hour, ran through a stop sign which they must have known was there, given that they lived just yards away. In addition, their callous disregard for the safety of others was shown by their failure, while the victims were being incinerated in their car, their failure to show any remorse or concern, to try to help, or even to inquire about the condition. Instead, they tried to remove evidence. The court indicated the appellant, Mr. Gonzalez, was fully aware of the condition of the accident scene, which would make racing there very dangerous. They had long resided in the neighborhood, within yards of where the fatal crash was placed, and inferentially knew the residential nature of the neighborhood, the traffic conditions, and other factors. Mr. Gonzalez was seen driving recklessly in the area just before the collision. The court in Gonzalez referred to Justice Gilbert's remark in the Moore case, which our counsel also discussed, at 187, Cal at 937, and 941. Whether Moore was subjectively aware of the risk is best answered by the question, how could he not be? It takes no leap of logic for the jury to conclude that because anyone would be aware of the risk, Moore was aware of the risk. Is that common sense as well? How could he not be? Going back to the Gonzalez opinion, The Court of Appeal stated the trial court pointed out that they were engaged in a speed contest at 80 or 90 miles per hour. How much more knowledge do they need? They've got several thousand pound vehicle that they're running at 70 or 80 miles an hour. What does it take for a person to understand that what they're doing is inherently dangerous to human life? Now here, Mr. Bohm was not involved in a street race with another person, but he certainly was driving at an absurdly high rate of speed to the data collector in his own vehicle. He'd also not drunk any alcohol, although Mr. Canizales was not stated to have been under the influence either. He had just consumed some amount of alcohol. Just as Mr. Canizales was very familiar with the area in which he was driving, so was Mr. Bohm, by his own admission. Canizales was aware of the conditions of that roadway and made driving like he did so dangerous to human life, and indeed likely to cause death. And so was Mr. Bohm, due to his own familiarity with PCH. It should be noted that it was also a factor for the court in Canizales that defendant's post-crash conduct was deplorable, and that played into their evaluation of his subjective awareness and his callous disregard for human life. Mr. Bohm, it must be noted, demonstrated no such callousness after this accident. The Moore case, which I quoted some of a minute ago, also was instructive, I believe. In that case, the defendant drove through city streets at excessive speed. He passed one victim going 80 to 90 miles per hour in a 35 zone, ran a red light, collided with another car, which in turn hit a third car, causing the death of one victim and serious injury to another. The defendant did not get out of his car and check on the victims, but continued to drive. When he was arrested, he claimed he didn't intend to kill anyone and did not experience any mechanical failure, but he was simply going too fast. And he admitted that he left the accident scene in some very callous manner. The defendant there conceded, in the Moore case, that the evidence was sufficient to support a finding of gross vehicular negligence, but claimed it was insufficient to show that he had any subjective awareness of the risk for manslaughter. Justice Gilbert rejected this claim. He stated, Moore drove 70 miles per hour and 45, crossed into the opposing traffic lane, caused oncoming drivers to avoid him, ran a red light and struck the car in the intersection without even attempting to apply his brakes. His actions went well beyond gross negligence. He acted with wanton disregard of the near certainty that someone would be killed. And that's Moore at age 941. And I think about this, how is that so different from the evidence presented at the preliminary hearing in this case? It's not exactly the same. It doesn't have to be exactly the same. Mr. Bohm was driving at the very least 70, maybe it was 80 or 85, and the objective evidence says it was 100 in a 45 mile per hour zone. He was observed to be driving erratically, moving from lane to lane, causing another driver to at least attempt to warn him to slow down before he hurt someone or himself. Several other drivers also noticed his very, very fast driving. One of them, I believe, honking at him. While Mr. Bohm did not run a red light, he did commit very, very serious traffic violations here by speed alone. I don't believe there was any evidence in this case that he applied his brakes either, not in terms of skids or that type of observable evidence of braking. And here, by his own admission, he knew how dangerous this was. His two friends, his best friends, were killed by driving at an excessive speed, extremely excessive speed, and he's very familiar with the PCH. And again, it's only reasonable to assume that due to that familiarity, he knows what a dangerous road it is, in particular, the area called the Dead Man's Curve, where this accident occurred. The magistrate, Judge Edwards' findings that the elements of second-degree murder were satisfied for purposes of the preliminary hearing were well within the realm of the reasonable. The standard is not at prelim beyond a reasonable doubt. That's for trial. I'm not saying what the evidence will look like. If the case does go to trial, whether the case will be proven, whether the murder case will be proven beyond a reasonable doubt, or whether it won't, nobody knows the answer to that. But that's not a question for today. The question for today is whether there was sufficient evidence for the magistrate to make the findings that he did, including the inferences that he made, the law that he applied, and I do believe that the magistrate's findings were well supported by the facts as they apply to the law that's operable in this case. So the motion is respectfully done. All right. motion. Mr. Helfand?
Yes.
The defense apparently subpoenaed under phone, tried to gain some information about his speed and his location, as well as any bias that he may have developed as a witness in this case. I haven't seen that actual subpoena, but that's what I'm surmising from the moving papers. Am I right about that?
It's attached to my declaration, Your Honor. I have another copy if you want.
Can I see that? Thank you. What is it, and to be as specific as you can, what is it that you are seeking from the collector's fund?
Thank you, Your Honor. I also submitted an updated proposed order that identifies exactly each item, so I'm going to refer to that document. The first, and everything is narrowly tailored to a specific date, so I'm not asking for unfettered access to certain information, just GPS location on the date of the incident, data establishing his location, speed, and velocity on the date of the incident. That would include an accelerometer, motion sensors, that sort of thing. We are also seeking communications with other witnesses. He testified at the preliminary hearing that he exchanged phone numbers with other witnesses that were at the scene, and he went to dinner with them prior to making the statements to the police, so we want to see if they're coordinating. We're requesting communications relating to the incident just generally.
Well, that's quite broad.